Without further ado, I'm going to ask Jennifer Norton to come. Jennifer Norton, Esquire, to come. Welcome, Jennifer. Good to have you. Thank you. God bless you.
All right. Hello, everyone. How are you? So I want everyone to Pastor is absolutely correct. I am not here to sell you anything. In fact, you can't necessarily even be a client unless I agree that you could be my client. So even though you may call my office, that doesn't necessarily mean we'd end up in some type of relationship from a professional capacity. So the first process in our office is this type of educational workshop. So everything that I'm going to tell you today is just information that you should take to evaluate your own personal circumstances. And Pastor is absolutely correct in that you shouldn't always listen to your friends. Everyone's situation is different. And when it comes to the law, one slight miscommunication of a specific fact could derail your outcome, resulting in the same outcome as your friends. So you just want to be very, very leery about communicating and telling people what they need to do, because a lot of people don't just, open up the closet and tell you what's all back there and in there. They just tell you what's pretty on the outside so that they can get to the next level. And so what you want to do is just take this information and then apply it to your own personal situation. I am only licensed to practice in the state of Indiana. So I know that we have people viewing online. So if you're in a different state, then you'll want to look to your state statutes or, consult with a practitioner in your area in order to make sure that the laws that we're talking about today, how do they apply to your family and your personal situation. So let's get started. So today what we're going to talk about are estate planning basics. Okay, so these are things that you wanted to know, but you didn't know that you needed to ask. Okay, so I'm going to bring up a lot of concepts. I've got some questions here in the audience. If you guys have questions, we'll have time for that at the end. And so I'm happy to answer any questions that you may have. Again, you may not tell me all of it, so I'm just going to give you a general outcome, what could have happened, because there may be other facts that I need to know that you might not want to disclose in front of all these people. So let's go ahead and get started. So welcome. Thank you for coming out, especially if you're here in Indiana, because it's snowing. And so that tends to keep people in the house. But you have nothing better to do than to listen to me. So come on in here and let's get started. So let me introduce myself. I am Jennifer Norton with Norton Estate Planning. I am from Indianapolis, Indiana, born and raised. I graduated, for the folks that are local, from Cathedral High School. And then I went to IU in Bloomington, and I actually have a degree in finance from the Kelley School of Business. From there, I decided to stay at IU, and I went to law school down there at what's now called Maurer School of Law. Law school is just a general degree, so I learned about all areas. And upon graduation, then I ended up working for the CEO of the National Network of Estate Planning Attorneys. I worked for him for about 4.5 years, and then I decided I need to start my own practice. And in particularly, my community in particular was missing out on the conversation about estate planning, and particularly trust-based estate planning. When I worked with the National Network, we focused on generational wealth, making money move from one generation to the next, protecting assets. And so we started the conversation, in my view, in the middle. And so my community in particular, even though we have the highest discretionary income in this country, we aren't even having the conversation about a will, right? We're still stuck on probate. And so we're going to talk about some of those conversations and some of those topics tonight so that we can elevate ourselves so that we have information to make a good decision for yourselves and your families, okay? I'm not here to tell you what you should do, but I am here to tell you what's out there. And then, of course, in this corner is my son. This is Ty. This is my world. This is my why, right? He is soon to be 10, and he is the reason why I do estate planning, to protect him, to create the legacy that I want to leave. And I have to do it with some intention, right? I can't just let stuff happen to me. So the biggest thing that happens when it comes to estate planning is when you have these conversations, people think, well, what is an estate? It sounds so high, affluent, right? I gotta have money to have an estate. Everybody actually has an estate, right? If you have a car, if you have a bank account, if you have a house, if you even have an apartment, that's an asset of yours. The contract is an asset of your estate that we would have to handle in the event of a death or a disability. So anything you own, investment accounts, retirement, if you have businesses, business bank accounts, If you even have a safe deposit box, that's an asset of your estate. So everything that you can think of from a financial standpoint is considered your estate. And then there's also the non-financial. So remember those things too, right? The stuff in the house, your jewelry, family heirlooms, all of those things are your estate, and they need to be settled if there is a death for sure, and there need to be a plan for it if there's a disability while you're alive, okay? So let's kick this off. So why do I need to start estate planning? Is essentially, what is in it for you? Well, there's not a whole lot in it for you except for protection during a disability, right? You get to pick the people that do the work or assist your family if you couldn't do so for yourself. Majority of the benefits of an estate plan come from a death, right? And it's to the beneficiaries. And so those are the people sometimes that you're looking for when it comes to, the end goal, I guess. But the more important question is, who needs an estate plan, right? Because a lot of people think, oh, I don't need an estate plan. Except like the younger people, I don't have much money, right? The older people, oh, it's all set. I got it all figured out. That's how my wise clients, my older, up in age clients tend to think. But there are certain profiles of people that need an estate plan. So we're going to run through them real quick, and then we're going to dive in. So, of course, people naturally think the people with children, right? So if you have minor children, if something happened to you or your grandkids, then who's going to run their affairs, right? Because they're too young to manage their own estate. And who's going to guide them through life? So this is an easy profile for people to think about. Now, the biggest thing, and I'm going to come back to this, is blended families. Okay, so about 60% of our families in this country are blended nowadays, right? So we really have to be intentional about the type of planning that we do when we're blended families so that we don't unintentionally disinherit our own kids. Okay, so we'll talk about that. The second profile of people that need a estate plan are people with assets. So those, even the people that think I have no money, right? You're shaking them upside down. That means something to the people that are going to receive it, right? So you may feel like you have no money, but the people that are the beneficiaries think you're oh so wealthy, and they'll take whatever you're going to leave to them. And then, of course, if you believe you have a significant amount of wealth because you have been saving, then of course you need a plan. People that need protection, right? People always think, oh, someone who's feeble, like older, or someone who's younger. So anyone that you think we need to protect, people with special needs, these people need estate plans, right? So that if you're not there to manage on their behalf, or you can't do so for yourself, what's the plan? People who value privacy, right? So if you don't want people in the public to know what's in your estate or what you have, the type of planning that you pursue is going to be very important in order to protect that privacy. People who desire tranquility, organization, peace of mind. Those are the people that need to be doing estate planning. They want to make it easier for those that come after them, right? That's a common theme when it comes to estate planning. And then, of course, people who are legacy driven. That's a big word. Everybody's throwing it around these days, right? So if you want to leave a lasting memory, especially when people are, I'm single and I have no children, what do? The conversation isn't solely about who gets my money. Right? We should be talking globally, more largely. Okay, do you want to start a scholarship or a foundation or leave to specific charities or causes or a combination of individuals in these philanthropic goals? So your legacy is going to all be dependent upon what you do today so that people can remember you in the future. So when it comes to doing an estate plan, it's clear that everybody fits in one of those six profiles. Everyone needs an estate plan. No one is immune from needing to get one. So the question is now what? What do we need to do next? So I don't know the answer to that, right? But the basic conversation typically falls to, do I need a will or do I need a trust? Okay, so let's dive into some of the concepts because you can't make a decision unless you know all the concepts. And the ultimate goal is you have to beat the clock. As they say, we know not the hour nor the day, right? So every minute matters. And so let's get started. The most common thing that people are very aware of is this concept of probate, where you have no will. Okay, so I'm not going to ask you guys to raise your hands and tell me who has a will and who doesn't. This is not a shaming situation here. But I am willing to bet a lot of people do not have an estate plan, okay? And so what you do know is that you will subject your family to this legal process called probate. Probate essentially is this morbid scavenger hunt where people are trying to figure out what you own, where is it, what to do with it. In particularly, there's no registry that tells them where your assets are. We can't dial up your name in some little database. You guys would be upset about that anyways, because you're already upset that the government's in your business. Now they'd really be in your business if we had a registry and we could find out everything you own, where is it, who it's supposed to go to. And in particularly, land is the most difficult because you have to know the exact state and the exact county in which that property is located in order to capture and find that piece of property. And so that becomes a challenge, especially if your family and your elders are of that old school mentality where it's fine, don't worry about it. So when a person dies, they just keep leaving stuff in grandma's name and great grandma's name. And so now by the time it gets to your generation, you have 16 different owners. Because back in the day, I don't know if your families are like my families, both my parents have 10 siblings. So, and then some of my first cousins have 15 siblings. So we have a very, very large family. So the longer you let property sit in a deceased person's name, the more owners you're going to have to deal with. And somebody inevitably says, you need to buy me out. Somebody is not going to just turn it, there's somebody that's not just going to turn it over. They want to be bought out. And so that becomes an issue. So when it comes to your assets, it's very important that you understand there is no registry. We don't know where you bank. Clients call us all the time. Dad said he always had a life insurance policy. Where? There are hundreds of life insurance policies. And so it's very important that this probate process, you understand that it's a scavenger hunt, because the probate court is mainly concerned that a person's final debts, taxes, and expenses are all wrapped up before the final beneficiary or the next in line heirs inherit. They also are concerned that they want to make sure that when you're wrapping up someone's affairs, that the creditors of the person are addressed. Okay, so when a death occurs, the creditors are out there and they're unknown. So what happens is the court needs someone to be appointed. And as long as someone's over the age of 18 and they've not committed a felony, they can be appointed as the representative or the administrator of someone's estate or executor of your estate. There's various terms that people call them. Once they're appointed, though, what happens is, prior to their appointment, it's the first person to the courthouse wins. So I literally had to do this week. I had to be first to the courthouse. So the family came to me and they're like, hey, we need to get appointed. We got some stuff on the horizon. We need to be first. And probate court is all about who's first. And as long as you have the legal, what they call standing, your next in line kin, it's not necessarily preferred, or it doesn't have to be preferred. Some statutes allow you to have someone who is like a business partner could be the personal representative because they have some connection to the estate, right? Doesn't necessarily always have to be a spouse. It could be the children. Now, again, like I said, some states have priority. Like in Indiana, we do have a hierarchy, but it is sometimes the first person to the courthouse wins, and then the person that's coming behind them has to prove why that other person is incapable of being that, and the court doesn't like to get it wrong. So you're going to really have to fight and really prove why that person shouldn't be appointed as the executor. Once they're appointed, they have to publish notice in the local paper, because if a person doesn't know what you own, they probably don't know who you owe either. And that process is called publication, okay? It's worldwide, it's called publication. Now, how many days you have to publicize is different from state to state. In Indiana, it's 90 days. So we have to publish in our local county or in our local county's recorder's office or newspaper's office notice of the death. So here we'll use like the Indianapolis Recorder. It runs 2 consecutive weeks. It runs 1 week and the following week. And for 90 days, the creditors have an opportunity to file into the estate. Now, they have to show evidence of the debt, swear under penalties of perjury that the debt still exists, and pay a filing fee to the court. Now, if they do all of those things, then their claim will eventually be allowed by the judge. If they fail to do those things, the claim will be disallowed. Now, what typically happens, though, in Indiana is a lot of we attorneys wait until the end of the 90 days. So we don't allow nor disallow the claim, because 15 days later in Indiana, it's called a 41E dismissal hearing. The judge will move to dismiss the claim if the creditors did not do everything properly. And the biggest thing that the creditors miss is pay the filing fee. Okay, now in Indiana, I can tell you right now, there are 2 creditors that are doing very well, and that's Indiana Members Credit Union. They are doing a good job of doing all the steps necessary to perfect their claim. And then there's a couple, and usually there are other creditors like school debt, right, taxes. Those creditors you can't really get around, right? Those people are always going to be allowed. They'll always be able to be repaid. If a claim is allowed, what we typically will try to do is try to negotiate the debt. We'll try to pay pennies on the dollar. We're not really trying to pay anybody in full if we can avoid it. But essentially, it's a 50-50 chance whether a creditor files into the estate or not. And so do you want to take that chance or not? In the probate process is up to you, right? But a lot of people don't like the probate process. They say it takes too long and it costs too much, right? It takes too long because you have to wait at least 90 days to get started in Indiana. In some states, it's even longer. I think Texas is longer. And so that process tends to cost too much because most attorneys are billable hour, right? So your family's grieving and they don't know where these things go. So guess what they do? They call the attorney. Can you help me? Why don't you just do it? And of course, the attorney's like, absolutely, come on in here. And then what happens is the clock starts running, right? And so what your beneficiaries end up, and you probably, if you've been a beneficiary of someone's estate, you already have in your mindset that the attorneys are going to take a lot of the money. Just leave me something on the table, just a little bit. Let me feel like I walked away with something. And that's not necessarily what the person, your loved one wanted for you. They wanted you to get the max dollar amount. But failing to plan can go astray, right? And everything can go off kilter. Because typically, the attorney's fees can be astronomical, right, when a death occurs, especially if you have businesses and we don't know where the business banks and where's the business insurance. Did you put someone's name on it? A lot of people, when they have businesses, they go and register themselves with the Secretary of State's office. They feel really good about that. I'm great. That's great that you did that. But what's key to a business is you must have an operating agreement. An operating agreement says who operates this business in the event of a death, a disability, divorce, retirement. What else is there? Disability, divorce, retirement, something else. But essentially what you want to be able to do is have an agreement that specifies who can take over the business and run the business if this were to happen. And so a lot of people fail to get operating agreements. If you ever try to go get a loan for your business, they're going to say, well, can I get a copy of the operating agreement? So if you never get a loan, you might never get an operating agreement. But if you do try to go get financing, then chances are you're going to get an operating agreement in order to secure that. So one of my biggest recommendation when it comes to estate planning is you need to get yourself in order today. This is your stuff, folks. Nobody wants to organize you. I mean, my sister and I literally, she did more of the work. I will give it to her. We organized her pantry last weekend, and that was a nightmare. Like, a nightmare. Like, why do you have so much stuff? You are a hoarder of food because she loves coupons. She's got good food, but she has a lot. So if she does that with her food, can you imagine what other people do with all these other assets and stuff that they have? So my recommendation is that you guys organize. Now, I will give it to my mother. My mother and my father, they do have estate plans. So they did at least take that recommendation. But what you want to do is start getting a good list of your assets. If you're welcome to email me. I know Pastor has the personal information form that you guys can use. And this personal information form, what it does is it allows you to lay out where you bank, where your investments are, who's your property and casualty insurance for your house, what about for your car, do you have stocks, do you have bonds, do you have real estate, does people owe you money, do you owe people money? So this form helps us to kind of organize you today so that you can see the project, right? Make sure you address them throughout your entire estate planning process. So again, here's my email. You're welcome to email me directly. You're welcome to reach out on the website and reach out to Pastor Hudson. He has a copy of this form as well. Sorry, I forgot to bring handouts, but you reach out to us and we'll get them to you. So when it comes to the probate process, I've just explained it to you, right? By getting yourselves organized, then at least the probate process can be efficient, right? We can get through it quickly. The minute that 90-day tolls, then we can figure out who all your creditors are, right? And then subtract that from everything that you own, and then we'll distribute to your next in line heirs. Now, when you have no plan, your next in line heirs is typically determined by the statute of your state. So I do want everyone to be very, very cautious about relying on the statute. People think just because I'm married, everything's going to go to my spouse. That is not the case, especially in the state of Indiana. In Indiana, if everything has a beneficiary, like life insurance, retirement plans, annuities, those are beneficiaries. So by law, by contract, they're going to go to whoever's listed on that contract, okay? But if you do nothing, if you leave like a car in your own name, a piece of property, an account, then we look to the statute. And Indiana statute says half to the spouse, half to the children. How do you feel as a married person giving half your money to your kids? Right? That is not an exciting thought, is it? So don't assume that married people automatically get your assets. That's not the case. Remember, I talked about blended families. Even worse in the state of Indiana. In Indiana, they will give 50% of all of your stuff to the spouse, 50% to the kids, especially if they're not your children. But how they treat the real estate is the most important. Real estate in Indiana, they will give ownership to the child. Mind you, these people live in this house, right? This is their marital home. They will give ownership of the house to the child and give 75% of its equity to the child, 25% to the spouse. Can you imagine how many people get their eviction papers when a death occurs, especially if they didn't like her? Sorry, fellas, in my stories, the husbands will always die first. Do what you want, but you're going to die first in these stories. So women, if you don't have a good, sound, solid relationship with these children, you may be getting evicted. And so you need to be very cautious. And you may think you have a great relationship, but we all know what money does and a death occurs. And then people think they're entitled to something, right? Then the next thing you know, what you thought was all roses and sunshines and butterflies becomes a really, really bad day, okay? So what you want to do is make sure you check your statute to see how does it treat you, whatever your relationship is, or to your beneficiaries in your state, because Indiana is not so kind, okay? Now, let's talk about a will. Sorry, I hopefully went to it. Okay, so a will is nothing but a set of instructions. It tells your property where to go, okay? So people feel like they're in more control. You get to pick the person that does the work. That's why they're called your personal representative, okay? You may say in your will, I want all my money to go and all my assets to go to my spouse, or I want these assets to go to my spouse, and these to go to my children, and these to go to my godchildren, my nieces and nephews. So, of course, we're more on target because you have a will. You have a set of instructions. And you've also picked the person. Now you have succession in case that person couldn't serve. But there are two things that most people don't know about wills, okay? This is very important. The first is the wills only control things in your individual name. So again, if you own things jointly or have something listed as a beneficiary, by law, the minute a death occurs, ownership has transferred to that person. So you can't put in your will, say you're in a blended family, you can't put in your will, I want half my bank account that's jointly owned with my husband to go to my children and he gets the other half. No. It doesn't work like that because the minute the death occurred, it already left. Ownership is already transferred. They just didn't receive a death certificate, right, in order to take the person's name off. So what happens when you are married, if you, so this is no surprise to married people, but I'm just going to here to reassure you, just because you're married does not mean you have to agree, okay? Which means your plans don't have to match, okay? But if they don't match and you continue to own things jointly, then the first person to die loses, right? Because if you own everything jointly, by law, it went to the survivor. We never used your will, right? So when you want to use a will, you have to take things out of joint name and leave it solely in your name so that your will can control those assets. Does that make sense? The second thing that most people don't know is all wills go through probate. So you hear a lot of people say, will, I want a will. But did they tell you that wills go through probate? Did the attorney tell you that wills go through probate? You got to guess why the attorney didn't tell you? Remember that wagon? No, just kidding. So the reason why wills go through probate, excuse me, I'm gonna give you some of the things that I have come to believe, and probably I guess maybe the legal community maybe came up with these reasons. But the biggest thing is institutions don't want to give the money to the wrong person, right? The person that becomes your personal representative has to be over the age of 18, not commit a felony. How's the institution going to know that? They just going to come in with the wills. Read right here. There's my name. I'm them. Here's my ID. But we all know, this is definitely not me, that people can have fake IDs, right? We were all under the age of 18 trying to sneak into some place we weren't supposed to be at some point in time, whether you created your own or borrowed somebody else's. And sometimes if you look just right, you have similar traits, people just look and go. So institutions don't want to give the money to the wrong person because of their background or the ID just really isn't them. Secondly, how do we even know it's a good will? Do we want institutions determining that this is a good will? So each state has different requirements for a valid will. So people think, oh, I'm gonna go get my will notarized. What if I told you that the state of Indiana does not require notarization? It could care less. They only want two disinterested witnesses, people that could never, ever, ever inherit under that will. But I find often people, your internet professors, your Facebook professors, your Instagram, people that tell you this is the way, just do all of this. Some of it is unnecessary and it's not even required. And then some of it they think is required is not, it won't make it even valid in our state. So you want to check your state's requirements. And I've literally had clients come in with a will and I could tell that the paragraphs had different fonts on different pages. You wonder why? Like I said, you realize these fonts are off and the numbers are off. It's really hard especially when you use Word and you're trying to line up the outline. Then it's like, okay, let me line it just right. And then the pagination and the bullets don't line up. So what happens is people do forge people's wills, right? They come in and forge people's wills. So institutions have big pockets. They don't want to be sued. So they say, go to court. Let the judge tell us this is a good person and this is a good will, right? So probate court is there to validate the process, the instrument, the people. The other reason that I think, and this is just my lowly opinion, and I'm just one small little black girl that lives in Indianapolis, Indiana, you don't have to take my advice, but think about it. Your family's still going to go on a morbid scavenger hunt. So for the people that do have wills, again, I'm not telling you, I'm not shunning you, at least you have something. But if the will says all to my children, all to my spouse, all my bank accounts to this, the first thing your children, the two questions that your children have when they come in our office are what? Where's the money? When do we get it? And if you only put all, how helpful is all? Great. Where's it all at? That's the question they ask us. And God forbid they go back to the attorney that drafted it. So did your attorney, if you've gotten an estate plan, did they ask you where all your stuff is at? Probably not, right? And even if they did, when's the last time you updated that thing, right? Bank One no longer exists, folks. And I still get people's wills and trusts that have Bank One. Sorry, guys, that's Chase now in Indianapolis, right? That bank is not around. I mean, yeah, the accounts and stuff all switched over to Chase, but your plan is outdated, which means the law's probably outdated and so are your family members and the distribution. People come to me and they're, oh, my kids are grown. They don't need a guardian in the will. Well, okay. Took you 18 years to figure out to up the, glad we didn't have to use it during that time. So essentially what you want to do is think about when it comes to the will-based plan, probate is there to usher people through the process because they don't have things in order, right? So they still got to guide them through it. So are you still lost and confused, right? Am I supposed to go get a will? All right. What I don't want you to do is chase your tail, okay? So what I'm going to tell you is if you think that you want a will-based plan, in certain states, in Indiana, again, and Michigan, I think, are both these two types of states, you can put beneficiaries on everything that you own, called transfer on death, TOD, or payable on death, POD. Again, the minute a death occurs, ownership transfers. So you can put transfer on death designations on your bank accounts, your investment accounts, bonds, stocks. What makes each state unique, though, is can you put it on real estate and motor vehicles? Indiana, the answer is yes. So we can do what's called a transfer on death deed for your real estate. So the minute a death occurs, ownership is already transferred. Someone just needs to come in with an affidavit called a survivorship affidavit. I am the survivor if their name is currently on the deed, or I am the heir if their name isn't on the deed. It's called an heirship affidavit. Simple change of the word, but it's an affidavit. My loved ones died, now I'm the owner. And that person doesn't even need to fill it out. Anybody can fill it out for them, as long as it's true. That's the main thing about the affidavit, as long as it's truthful. The other thing about Indiana is you can put a beneficiary on your car, okay? So we can go to our Bureau of Motor Vehicles and put beneficiaries on our cars. Not every state is like that, okay? So you want to check your state law and see, is this an option for us? When you're doing this option, just know that when you put a beneficiary, by law, ownership transfers. So if you're trying to control the outcome, how the inheritance is used, you can't do that with a will. You give all that up. So you're giving it to your beneficiary. They get to keep it. If they want to give it to their spouse when they die, or if they want to give it to a charity, if they want to go squander it all, That's their prerogative. You lose all control after it's transferred. Okay, does that make sense? No instructions can follow those pieces, that inheritance. So transfer on death designation, some of my older clients are like, it's very simple. My kids are doing very well. They're well off themselves. I just want to avoid probate, minimize taxes and things of that nature. No unnecessary process. Let's put beneficiaries on everything. Cool, let's do that. So what we do is we sit down with them and figure out the splits that they want on everything. And then you go touch each asset. How can they touch each asset? Because they organized it, right? They use that personal information form, so they make sure. And then what you want to do is when you make sure everything's been updated, get that confirmation from the institution, because just because you sent it off does not mean the institution received it. I've sent plenty of documents to institutions, and they have no knowledge. And I'm like, the fax confirmation is right here. They have no knowledge of my paperwork. So you want to do follow-up and make sure that you get some type of documentation, confirmation from that institution, and then put it with your assets. So it's all together. We have all of our instructions, we got every asset, and we have a confirmation. The reason why the confirmation is helpful too is because if things change in the future, you fall out with that beneficiary, the beneficiary unfortunately becomes ill or special needs or dies, then it's easy for you to know which assets you need to update. We don't want to leave deceased people on our assets, okay? That causes the probate for them because it'll go to their estate, right? So we don't want to cause other people a problem. The next concept I want to talk about is a revocable living trust. Okay, this is just like a will, it's a set of instructions. It can avoid probate. I'm still an attorney. I say can, not will, okay? There are a lot of people right now selling, and I do mean selling, revocable living trusts. A trust that you can change as long as you're alive, and then when a death occurs, it becomes irrevocable. Now, you can set up an irrevocable trust today, but that's a topic for another conversation, okay? So we'll do that later. But essentially, a revocable living trust. A trust can avoid probate, but what you have to do, and this is the biggest miss especially when you're on the internet, is you have to retitle all of the assets that you own today into the name of your trust or coordinated the beneficiaries with the trust. And when you die, everything needs to be in or coordinated with that name of the trust. If you leave something out, if it has a beneficiary designation or if it's jointly owned, that's okay, right? Because the minute a death occurs, it's gone. But if you leave something out without a beneficiary designation, without joint ownership, when you do a trust, you get a will. It still says last will and testament, but it's known for its functionality. It's called a pour over will. Go get my asset that I forgot to put and coordinate with my trust or put a beneficiary on and pour it over into my trust where all my instructions are. But what did I say about wills? All wills go through probate. So if you get a trust and you don't what's called fund the trust, retitle it, and you leave two, and in certain states they have a threshold, because there's a lot of people dying, there's a lot of people in the world, so the courts can't take on every death, right? So in Indiana, the threshold is $50,000. So if you leave an asset that is worth more than $50,000 outside that trust, and the will has to go get it to pour it over so that the terms of the trust can control it, that causes a probate. I'm here to tell you that I was on in one of my friend, some of the colleagues that around the country, we have these lawyer groups. And the biggest topic literally 2 weeks ago was who helps their clients fund their trust. And I'm going to tell you that there were maybe a handful that said yes. Me, a couple of the colleagues I knew that were in that group, and then some other randoms people. But most of them complained. It's too much work. They don't want to pay. Why would I do all that? They don't care whether you go through probate. You do though, right? You cared, but they didn't tell you that if you don't do this, their biggest excuse was, I gave them a list of instructions. I told them to go do it. Most of the people in law firms like myself that we do not trust you to do it. You ain't gonna get it right. So, and I don't want to be in probate unnecessarily. But most of my colleagues and my friends of the national network, for sure, we all help our clients fully fund our trust. But the biggest thing that we find is that those attorneys say, we helped them with the deed, right? Because y'all can't do the deed. Okay. But everything else, they gave you instructions. And not to mention, remember, Bank One ain't Bank One no more. And I'm not here to bash Chase, but it's not our favorite. They're not the favorite banks of estate planning attorneys. So can you be sure that Chase took your trust name and put it back into your trust name when they took over Fairbank One, right? If a bank merges, any institution merges, can you, without a shadow of a doubt, know that the way it existed is the way it's going to end up when the death occurs? Not necessarily. How many of us buy new houses? Oh, title companies love to say this. When you refinance, they want you to take it out and they'll put it back in. I've had my clients, matter of fact, we're going to do an announcement to them and I've got to do it, matter of fact, tomorrow. It's everybody that refinanced, because they all did with the new interest rates, right? Go check the title company. Did they really put it back into trust? Because sometimes they don't. Literally was working on one of my clients last week, not in trust. She thought it was. They gave her the paperwork and told her, hey, it's in trust. Make sure you do this X, Y, Z. When we went and looked, not in trust. So you must make sure that your trust is fully funded, because what's the point? If one of your goals was to avoid probate, you just missed the mark completely, okay? The other thing, when you do a trust, when you retitle your assets into the name of your trust, everything still stays under your social security number. So to the IRS, it's like you took money from one pocket and you put it into the next. So for instance, I have a trust. My bank account says the Jennifer Norton Living Trust dated June of 2010. My investment accounts, Jennifer Norton Living Trust. My beneficiaries on my policies are coordinated with the trust, right? They say the name of my trust. Even the deed to your house, you own your house. The mortgage is merely a lien, right? So if you sell it, pay us back first, but then you can take the rest. So if you leave it in your own name, you take it in your individual name. But if your house is in the name of your trust, then your trust will take the surplus, okay? So think of it like a box. You got to put everything in the name of that trust while you're alive. Because if you don't, then again, we go through probate. So is the trust a waste of money? For some people, yeah, absolutely. It is absolutely a waste of money. Now, why will people want to do trust? Let's talk about the nuts and bolts, because you can avoid probate without a trust. I just told you how. Transfer on death, TOD, payable on death, or put people jointly on accounts or jointly on property. Now, there come some stipulations when you do that, but again, topic for another. I can always come back, Pastor. But essentially, what you want to do is when you do a trust-based plan, there are two ways to draft a trust, okay? The first way to draft a trust is you set up a trust, put all your instructions in it, because the trust will then control all the assets that have the name of the trust on it, right? And in the trust, what you do is you retitle all your assets into the name of the trust. So it's fully funded. And so when the death occurs, don't worry about probate, because everything's in the name of the trust. Now what we look to are the terms of the trust. If the terms of the trust say, give it to my beneficiary outright, free of trust, that means we gave it to the beneficiary. They can put it in their bank account, their investment accounts, all under their social security numbers, okay? So if they have lawsuits, divorces, illnesses, their estate would be available to that creditor. Their estate is tied to their social security number. So the inheritance you left to them is now subjected to that creditor because they got it outright. Doesn't that sound like a will, basically? Why'd you buy an expensive trust to get the same outcome as a will? I'm just saying. Option two, right? You catch that on, as Pastor would say, catch that on the way out, okay? Now, option two is you can leave assets in the name of, in trust for your beneficiary, in the name of a trust for the benefit of your beneficiary. So think of, look at this box. Remember, when a death occurs, the trust now becomes irrevocable. And if you didn't give it to someone to put in their own name under their social security number so that the IRS can track them and they can get their investments, if you left it in trust for that beneficiary, to the IRS, what happens is your social security number dies with you when you, bless you, your social security number dies with you when a death occurs. And then the trust is kind of like born to the IRS. And everything that's born in this country requires a social security number, right? So when you leave assets in trust, you can protect beneficiaries from their later creditors. Think of it like a little lockbox, because each little trustlet has its own social security number. And so if your beneficiary has a creditor, like a lawsuit, a divorce, an illness, like Medicaid, where we want to spin down your assets, right? Your assets are tied to your social security number. These creditors they'll say, well, we need your assets, beneficiary. And I said, okay, here's my assets under my social security number. They said that that's not enough. We need those assets over there that you inherited in that trust over there. She said, oh, those aren't my assets. Go check out that social security number. I don't own those assets. Those assets that were left in trust, I just have the right to use those assets for what my my loved one has set up for me as a beneficiary. Okay. So when you do trust-based planning, the way you can draft it is you can draft it as option 1. You put everything in, you look to the terms, and then just gives the beneficiary the inheritance because they're grown, they're doing well for themselves, they're successful in their own right. All the reasons that people come up with, right? Option 2 is no, I'm going to leave it in trust for my beneficiary. Because, their marriage looks good today, but who knows? Everybody, 50% divorce rate in this country, who knows? They may get a divorce. I've seen them arguing, they argue in the corner, so who knows if that may get out of hand later on down the road, right? We all drive down the road every day. We're a liability, right? We can get in an accident and we can be sued. And if our insurance doesn't cover it, they'll come after us personally. And then we're all living longer, but not necessarily better. So if I got sick, could I be subjected to needing to qualify for Medicaid? Now, strategically qualifying for Medicaid. So don't only think about today, right? We want to think about when you're thinking about trust-based planning, you're really thinking about the future and you're thinking about the beneficiary, okay? And so when you think of a trust, it is a contract, right? You can control the terms. So you could say, leave all the assets in trust for your beneficiary. And they have immediate access because they're fine. They're doing well and good. But if they got a divorce lawsuit or some type of creditor, the inheritance is at least protected. Or you can do terms. I always give the example of minors, right? With minors, they can't own things in their own name. So we have to leave assets in trust for them. If you leave the trust under a will, it's called a testamentary trust, right? Last will and testament. We're in the church after my Bible readers, testamentary after death, right? So, but if the trusts are underneath the will, remember all wills go through probate, means we have to go through probate to fill up their trust. Does that make sense? And then attorneys, what they say is, well, when can the kids get the money? Right? And you're like, oh, what do you think? And the attorney said 18, 21, 25, 21, 25, 30. These are forms people are selling you. That's why I can rattle them off like that. What they're saying is at those ages, we're cutting checks to your beneficiaries and they can do what they want. Does 18 sound like a good age to leave a third of your inheritance? And then 21, they're going to be big man on campus, all right, for the very wrong reasons. And at 25, what happens is they realize, dang, I screwed all that up. Now I got to use all this money that I should have been using to set me up to clean it up, right? That's not a good look either. Now, if you'd known what you know today, which is you can leave assets in trust, then phase access in at certain ages. And it doesn't have to be 18, 21, 20. It's whatever age you want. So for my son, for example, what I did, and this is a similar contract what I have for my son, while he's under the age of 22, I picked who runs the money. Now, in the will, you always name who the guardian is. Guardian is who raises the child. The trust is about who runs the money. They could be separate people. You could run it like a board. You could say these people raise the child, but the money's ran by one of the guardians and my best friend or the uncle or your parent or whoever, right? So what we did for my son is while he's under a certain age, I picked who runs his money. Back in the day, it had to be banks and corporate fiduciaries. Does not have to be that anymore, right? You just have to have certain rules have to be met to ensure that the trustees run trusts, that at least one of the trustees is considered independent, right? They can't be swayed. Now, I won't go into that. We can go into that another time. But essentially, we said while he's under the age of 22, I picked who runs his trust share. At 22, he can come on the accounts like a co-pilot. Come from the back, come from the front, and you can work with them. Isn't that great, Ty? He thought he was getting a check. No, your name gets to get on the account, buddy. So now you got to go to the meetings. So before, I could have told him, I want you to engage him in these meetings to learn financial literacy, etc. But now at 22, if you want your name to go on the account, you better be at the meetings. And how long is he there for? How long does he have that co-pilot, that co-trustee? How long do they train him? We call it a training trusteeship. We're training our trustees in the national network. So we said from 22 to 40. Why I picked 40? The world's wealthiest individuals said that they didn't believe their children were ready to manage finances until 40. I ain't got nowhere near as much money as them folks. So I'm going to take their wisdom and put it in there. The other reason why I pick 40 is money typically doubles every 9 years. And the younger that you are, you should have life insurance, right? Whether we have a combination of whole life and term, all whole life, term, and some investment accounts. In general, we should be building our wealth, and participating in our employer's 401k, especially if they're matching. That's free money. Start our own 401ks and be contributing, acquiring real estate, whatever the case may be to acquire your wealth. Just imagine whatever that number is, every year, every 9 years, money typically doubles. So if I take, my son is only 9. So if I did, just do 10, you mad, 10 to 20, it doubles. 20 to, 10 to 20, or basically 19. 10 to 19, it doubles. And then from 19 to whatever, it doubles again. And then it does again. You see the number gets really, really large, right? And the stock market typically does better than 4 to 5%. So I could then apply 4 or 5% to that number to determine how much interest only is being thrown off those assets. When I did the math, that is an astronomical number. And my son can live on interest only, hence the term. No principal. Then the great thing about a trust is you can control the direction of the inheritance. So if you want it to go down the bloodline, or half of it can go down the bloodline and half I trust him to do what he wants with it. Or half I want to go to start, this scholarship for attorneys, people that want to study finance at Indiana University. Then I can control the flow and how things are transferred through a trust. So when people talk about generational wealth, right, it's about controlling from the grave. So when you say, I don't want to control from the grave, you don't want to trust. Okay? You want a will, which is fine. And there's no shame in that. What I always encourage people to do is look with the end in mind. Look at your beneficiaries. That's going to tell you which type of plan you want to do, right? Whether you should do a will-based plan and you're giving it outright, or if we want to do a trust because we want to protect our beneficiaries from themselves or the outside world. Because a lot of times, generational wealth will never occur unless you do planning. And in particular, you need to do trust-based planning if you want it to go multiple generations. Okay, we'll get to the first generation. They say the studies show that 70% of the inheritance is blown in the first generation. 90% is blown in the second. Okay, so if that is your trajectory, then there you go, right? If it's not, then it's not, right? You have to do something. Because a lot of people are not doing generational wealth planning. I've been meaning to say this, but I'm going to say it now because this is the truth. They're creating memories. You're not creating generational wealth. You're creating memories. And in fact, they're horror stories. They're nightmares, folks. Nightmares. Like, this is not generational wealth planning just because you acquire wealth. Acquiring wealth that's all well and good. Who cares if they're going to blow it anyways? Right? So be very intentional if that's what you want to do. If you don't, okay, that's okay. But one of the things I've learned in the National Network, there's 2 types of learning. Earned learning, right? School of hard knocks, and learning. You learn from someone else creating methods, right? So we would love to be in the learning, where we've watched somebody else mess up and we make course corrections. But do we see that happening? Not really, right? Everybody talks about it, but as Pastor said, let's take that step today, right? Let's not wait. One of the biggest lessons I've learned in practicing, I've been practicing for 12 years. I've had my own practice for the last 8 years. I have over 300, last count I counted was 332 clients in my maintenance program in my law firm. So these are people that have trust-based plans. We maintain their plans. We review them biannually and update them. And one of the biggest things and lessons I've learned in my 12 years of being in the National Network and being a relationship-driven type practice is that you need to engage the family. A lot of people do planning and leave the family out. That's horrible. Like, even if you're disinheriting them, I don't care. Bring them all to the table. Or if they're not going to do anything, bring them all to the table, because that's where the drama occurs, is when the death or disability hits. And people, especially you oldest children, I'm one of those. We think we're supposed to be doing everything, right? We may not be the best suited. My sister is the CPA, right? She's better doing all that Detail work, great. You know what I mean? I'm going to make sure, I'm a process person. I'm going to make sure the process gets carried out. My brother's aloof. He doesn't care. Just don't jip me. You know, I can do math too. That's my brother. I can do math too, which he can. He's super sharp, but he's going to sit back and let us duke it out, essentially. So it's better to have the troublemaker at the table today than to have him later. Okay? And I love those conversations because I always tell people, you're auditioning for these positions. If you believe that you should be in the position, then please have the floor and tell your loved one why they made a mistake. Do you think anyone has ever challenged that? No, they know. And even if you think you're super available and I was able to do this, you had 3 kids, you was working 2 jobs, you were not available at the time I did this plan. That's why you weren't in it. So if you have a conversation today, then we can get rid of all that heartache later. It's very important, too, to include any financial advisors you may be using. CPAs, right? We want to use your people. If you're disabled, you don't want your people going to some random financial advisor, especially if you don't like the way they run their finances, right? What's the point? You want your team to be controlling your plan, so you need to get them all to the table today. The other documents, and this won't take long, is you want to get a financial power of attorney, right? A financial power of attorney, and typically you want to get a durable financial power of attorney, one that lasts until a death. Everyone, if you don't know this, you will know it today. They are no longer valid when a death occurs. Okay, so stop taking them around like they're valid when a death occurs. It does not matter. We do not care that you're the power of attorney and a death has occurred. Okay, so you want to get your financial power of attorney. In my view, I like to name 2. This is a lot of work if you're disabled. I like to name 2 people. It's like internal checks and balances. No one ever names someone they think is going to run away with the money, but it does happen. Okay, got a call last week. What can we do? Does the cost of pursuing it outweigh the cost of what's going to cost to get the thing back? She has to make that decision. And so naming 2 people is like a checks and balances, at least in mine. But it's your plan. You do what you want. You can name 1 person, have succession. I just tell you what I like to do. Okay, so my recommendation, like I said, name 2. And then have succession so that you have someone serving. You also want to get your healthcare documents or advanced healthcare directives. So some states call them advanced healthcare directives. They should include your healthcare power of attorney, your HIPAA, which is an authorization to disclose. It should be either embedded in the document or it could be a standalone document. And your living will. Living will, you're alive, but not so well, right? So your healthcare power of attorney, it says you can sign me into a nursing home, you can sign me into a hospital, and you can sign a contract that someone come out to my house. It doesn't say which one you prefer, okay? They can do whatever they want. So my recommendation is, again, only name 1 person, because doctors don't want to come out to a committee decision and people can't agree when it comes to health. Unlike money, 2 is good, but health, 1, right? And then have succession, in case they couldn't serve. But have that meeting, again, to tell them, okay, maybe you're just the messenger. You're not the boss. I still want you to consult with all these people, right? So have the family meeting to talk about your health. Like I said, you need to get your HIPAA. That's the authorization to disclose. Your Health Insurance Portability and Accountability Act. Attorneys like words. And then they love acronyms that you don't understand. Okay. And then, of course, like I said, you need to get your living will, right? You're alive, but not so well. Do you want to be prolonged with artificial nutrition and hydration? It's a pull the plug, not on you, the machine. You see, it's in the wall, people. So living, because you're alive, as opposed to the last will. So people always come, I think I need a living will. You really mean the last will? Because living will, there's no timing in that. The healthcare person that you appointed as the agent under your power of attorney, they determine whether or not we're going to pull the plug. So you may say, I don't want to be prolonged. But maybe they're like, oh, I love mama. I need a second opinion, a third opinion, a fourth opinion. You're going to be trugging along until that agent determines I'm satisfied that this is not going to, we're not going to recover from this. So when you're talking about the living will, you want to be sure that you're appointing the right person in the healthcare power of attorney because they're making that decision. So again, what is your journey? I don't know, right? That's all up to you. You are in complete control. The one thing I do want you to do is make sure that you're not outsourcing your family. Make sure you're working with counseling-oriented attorneys, right? People are going to sit down with you and tell me about these people. Like, this ain't, my practice. I don't know about other people's practice, so I don't want to comment, but my practice ain't Burger King. You ain't going to come in and have it your way necessarily. Okay, so because you're going to tell me, and I'm going to say, well, why? And then I would say, well, I don't think that's a good fit. I would see that, how does this play out given their personalities? So I'm going to challenge my clients to look at their people and make good decisions. But not every attorney is like that. Some attorneys, and this is really the bane of my existence right now, is they add it on because it's easy. But then when the death occurs, they want to send them my way. What in God's name, Lord, why would you do that to me? Because it's a mess. It's a mess. So there are people that add estate planning onto their practices, but that's not what they do, folks. You don't go to the family doctor to get heart surgery, right? So why would you go to your criminal defense attorney to get an estate plan? Do your research, okay? Right? People online got these forms. Do your research. Have you even settled up a trust? You're drafting them. They don't know what in God's name to do after the death occurs. I've literally had attorneys bring me the trust. Jennifer, you go and fix that up. Really? And then it doesn't even play out nowhere near what the family anticipated. And I get to be the bearer of bad news. So people, please, please, please research your attorney. Who cares if they've had years in the legal practice? What were they doing, right? Were they practicing estate planning? No. Can they have transitioned to estate planning? Yes. That's okay. But you need to make sure that they feel comfortable giving you an advanced level document and then carrying it out for you. If they don't, you shouldn't hire them. Last point is checkup. Just like we go through life, we go to the doctor's office. We may feel all well and good, but even when you try to get on Medicare, right, government health insurance, they make you go get a checkup, even if you didn't want to go for the last 30 years. You gonna go get that checkup, right? So when it comes to your estate planning, you should be revisiting it. Now, you can do your own internal schedule. I'm gonna go every 5 years, every 3 years. If you have a financial advisor, they're gonna push you to review it, and that's good. That's the great thing about financial advisors and CPAs. You're usually gonna go check on your money. Well, guys, this is the vehicle that's gonna control it. We need to check on it. So what you wanna do is try to figure out a pattern so that you can revisit it. Now, because we know your family dynamics change, we know the law will change, so you want to make sure everything is in sync when the time comes to use it. Now, you can work with practices like myself, like my colleagues in the National Network of Estate Planning Attorneys. We have formal maintenance programs, I already mentioned it, where our clients routinely update their estate plan and revisit. In my practice, they biannually. It's not required, they don't have to, because there are people that are not on the maintenance program, but they are in a relationship-driven practice. We still keep in contact with them. We still tell them when the law changes. And then when they come in, they'll just pay an hourly rate or whatever the agreement is with the firm. So essentially, you want to make sure you're inquiring with whatever professional that you hire. Are you going to call me when the law changes, or am I supposed to call you? And with each administration, there is a change. Okay, so if you want to tag it on to when we change presidencies or move things in government offices, that's a fine time to go revisit your estate plan. But remember, it changes pretty frequently. So you just need to get in a rhythm and get it checked up. Now, the main thing that the checkup does is it helps you determine who's in charge of your estate plan. Because when a death occurs, do you want it to be the attorney that's running the plan, where the fees can then get astronomical? Or do you want to be out in front of it, proactively, staying in front of it and keeping the costs? There are fees, people. A lot of times you can control the fees if you're being proactive, because it can get away with you if you don't. Because no one wants to be nickeled and dimed, right, when a death occurs. Because that's exactly what it feels like when a death occurs, is we're being nickeled and dimed because we're ill-prepared. The last little bit of information I'll give you is there are 3 fees to an estate plan. There's the front end fee, which is the planning fee. You're always going to ask somebody how much you're going to charge me for it. Just know it is a document, okay? So if you assign a value to just the document, then because that's all they're providing you, that's fine. But if you're seeking counseling, you're going to pay more, folks. But you got to make sure you're getting counseling when you're paying more. Okay, so just because someone's charging you a high dollar amount doesn't mean you're actually going to get the value. So you just want to make sure you're inquiring to that. The second fee is, what if we become disabled, right? Because if you become disabled and you have no plan, you're looking at what's called a guardianship or conservatorship in your estate. Guardianships in Indiana start out about $4,500 uncontested. I've seen a contested one as high as $8,000. I saw a $40,000 guardianship. because people are fighting over a job that once they get appointed, they realize, why did I do that? Because it is a lot of work coordinating between the doctors and the rehab and the care and then making sure you have your meds and the pharmacist. It is a lot of work, folks. To be fighting over that position, you got to be some kind of crazy. So what I would do is, rather than fighting, figure out the plan and then how we're going to work together to handle it. And when you're talking to attorneys, they're always going to give you that famous word. It depends, right? So you just ask them, what's the high, the mid, the low? If I don't do a plan, if I have to come for a guardianship, what's the high, mid, low? If I get a will, you shouldn't necessarily need a guardianship, because in Indiana, especially in Indiana, powers of attorney trump a guardianship. So as long as the power of attorney was drafted and no, it wasn't forged, it was drafted properly, wasn't forged, things of that nature, the power of attorney should prevail, unless you're misusing the money, giving items to yourselves, right? When you have powers of attorney, you cannot, what's called self-deal, deal finances to yourself. Unless you do it to everybody. If it's equal, then you're okay, but not just solely yourself. If you do a trust and you're disabled, in a trust, you get to craft a panel that's a combination of family and combination of doctors. Doctors who know something's really wrong with you. Family, because doctors don't live in your house. They control the timing. Doctors can't trump the family can't trump the doctors. But they come together and make a decision of whether you're incapacitated or disabled. You want to make sure the document defines that, because that can mean anything. They could just disagree with who you couldn't have checked to and say, mom's lost it, right? So you want to know that the definition, like in my practice, due to illness, age, or for any other reason, you can no longer effectively manage your personal and financial affairs, then you will be deemed disabled, okay? But the doctors and the family have to come together. Attorneys do that paperwork that the doctors and the family sign off on. So when you do trust-based planning, you want to ask attorneys, if I became disabled, what's the fee, okay? Especially if it's transactional. You know there's going to be a fee. You ain't even kept in touch with them, right? Last fee is what happens at a death. What will you charge my family after I die? How many people have asked that attorney that question? I'm telling you, very few, right? And we already know now from today's presentation, that's where all the money is made, okay? And it doesn't matter if you get a will or trust, because most people are not organized. So the fee ends up being the same, because I told you the attorneys aren't funding them, so they're going to end up in probate anyways, right? So you want to know what's the fee. The attorney's going to say it depends. You're going to say it depends on what? And they're going to say it depends on what you own, and I'm not going to know what you own at your death. You're going to say that's fair. But because you came to this beautiful program hosted by Pastor Hudson, you're going to say, but I've organized my assets in this personal information form, and I am going to know what I own at my death, because I'm going to give you my own hypothetical. What if I died tomorrow with these assets? Now tell me a fee, right? They should be able to give you an approximate. You said you couldn't tell me because you didn't know my assets. I'm telling you, I know them, and I'm dying tomorrow, right? Okay, there you go. So you guys, now most attorneys may not have an answer to this question. The reason why is because when bills are due, that's what people pay when they come in. Oh, the light bill is due today. Then I'm going to charge you this so that I can pay the next 3 months' light bill. Some people just are that disorganized, they have no clue. And then some people are like me. Because we have processes, we have set fees, and we lock ourselves in if our clients have committed to staying organized, okay? So what you want to know is, okay, attorney, it's fair. I'm not going to pigeonhole you that, but just give me a high, mid, and low. That's all I'm asking, okay? Now, the ranges can be very all across the board. Like I said, in Indiana, you can see as high as 5 to 8% of your estate size. It's conservative as 2 to 3%. So if you 3%, you have a house worth $100,000, 3% is $3,000, and it only goes up because most people own more than their house, right? So I can tell you on average, a lot of my colleagues are charging somewhere between $5,000 to $6,000 for a probate if they're doing flat fee. So the newer age attorneys are flat fee, like myself. Yeah, some of the ones that are more your old school attorneys, or they're being taught by old school attorneys, they're still on billable hour rates. So good luck with that. Last thing, like I said, it's a family affair. Okay, so when it's all said and done, if you can understand the fees and make sure your family is engaged, you will be better off, because your family is not prepared unless they know what to do, how to do it, and how to pay for it. What to do, how to do it, and how to pay for it. And giving them just the attorney's card is not what I'm looking for as the answer, okay? Right? Again, who's in charge? That's what Come on, y'all. We up, right? It's Saturday morning. But that's all I have. I'll answer some questions. So in conclusion, the profile of an estate plan, who needs an estate plan? Everybody needs an estate plan. What are you going to create? You're going to create a will-based plan or a trust-based plan. Okay? That's what you're looking at. And remember, if you do a trust-based plan, you still get a will. It's called portable will. And you'll want your powers of attorney. Some people go get estate plans and they don't get the powers of attorney. Whew, that burns me bad. Okay. And then probate, of course, is that morbid scavenger hunt that I believe we all can avoid if we take proactive steps today. And so I want to thank you all for listening. And like I said, I'll take some question and answers right now. And this is, if you have to go, this is my favorite slide. I can lead a horse to water and you know the rest of that. If you had a, old school grandma like me, I can lead you to the water, but I cannot make you drink. So to answer some of the questions, I have a question. The first question I have is, which life insurance is best for adults, term or whole life? Can you have both? And okay, so I'll answer them. There's multiple questions. So life insurance is a good product. The problem that I see a lot of is people buy life insurance for funerals. That's not the purpose of getting life insurance, okay? So we want to get life insurance as soon as we can for a wealth transfer, as a means of transferring wealth. Now, paying off some expenses is factored into that, and funeral expense is one of the factors. You can get funeral expenses covered with life insurance by going to your funeral homes and talk to pre-planners for that type of funeral life insurance. But life insurance in general is about a wealth transfer. And when you're younger, it's because of a lack of wealth transfer. So you get it to supplement and this is where my finance degree comes in, folks. But so you want to get something to shore up the gap. Because if you're like me, you went to law school, you have $100,000 in debt, didn't have $100,000 when I came out. Then I had a son 6-7 years later. So need life insurance so I can give him some money and pay down my law school debt, right? So what types? The younger you are, the younger and healthier you are, if you can get both, right? You get your term policy so that it covers the 30 years. You get your whole life because you're in the healthiest state of your life. And a whole life locks in that rate, right? The term explodes after whatever the term is. Usually it's 30 years, 20 years, 10 years, whatever that is. And the premium becomes so astronomical you can't pay it anymore. So it's really good to get a whole life when you can. And then if you get the right whole life, you can have anniversary dates and you can increase. If you get term, there's policies that are convertible. So you can convert some of your term into whole life and lock it in at a certain rate. And so that's a good thing. That's a good product to get as well. What else did I want to say about it? When you have children, the minute they're born, you should be getting them whole life policies. My son has had a whole life policy. His little policy says 0 as his age because they don't have months. They only have 1 and up. And so I got him $150,000 life insurance policy. Cost me $50 a month. By the time he's 32, it'll be paid up. What paid up means is that it will be invested. The premium, and part of the premium goes for the cost of insurance, and the other part is invested in the market. And so it's making money. And by the time he's 32, the illustrations show that the premium the policy should be paying for the premium itself because of what it's earning. Okay, so that's a lot of information. I hope I'm being thorough. So everybody should get life insurance. And you should have it, if your parents can get it for you, then they can change the ownership to you because like myself, so I have kidney disease. I came out of nowhere. It's sporadic in African Americans, especially women. I believe it's because of the food we're eating, which is why I'm vegan for the last 3 years. But that changed my kidney issue, but I became uninsurable. I don't know, how old was I? 30, 31. So good thing I bought life insurance that was convertible and has anniversary dates so I can increase it. So you should always get insurance the minute you can, the healthiest you can. And even if you're not so healthy right now, still go because you can get policies and it's worth it. Okay, I'm done on that. Let me get off my soapbox. Okay, what is a living will and the cost? Okay, so I talked about the living will. So I think you really mean last will, right? Because a living will does nothing. It's only while you're alive. And I talked about the cost, so I covered that. Oh, I didn't. So the cost of an estate plan, the front end cost of a plan, it can vary from state to state. Okay, so I'm not going to, give you an idea, but I'll give the Indiana folks an idea. So in Indiana, you'll probably get a will-based plan somewhere between, I would say, on the very, very low end, if you're getting a form, $500. But more realistically, 1,000 to 2,000. If you're single, you're on the lower end. If you're married, you might get it at 2,000. If you have minor children and we have to put trust under it because you don't know the difference, you haven't come to grasp about the testamentary trust under the will and the probate stuff, then they might be paying a little bit more. Okay, a trust-based plan in Indiana, most attorneys charge a percentage of your assets. So that personal information form becomes very important because it has all your assets. You total them up. The percentage, roughly 0.5% to 1.5% is what you're looking at in Indiana. So on average, I would say somewhere between $3,500 and $5,500. Okay, if you're over about $2 million, you might be you're in the boutique firms. You might be paying about $9,000, $10,000. Okay, just think about it. The larger your estate, the more you're paying because the attorneys are assigning value to that inheritance and the assets that they're protecting. So you just got to make sure that they're actually delivering on the value is where you come into play, okay? But that's kind of where you're at. Now, there are attorneys like me and some of my colleagues that we do adjustments for young professionals, right? We got debt, we got kids. School is expensive for these kids. And if you're pushing them out back to back, wow, good for you. So but you need an estate plan for those folks. And so you going to pay $3,500, $5,500 may not be in the cards. So there are professionals that do price adjustments for people with minor children, okay? So just be on the lookout, ask the questions. If that's not a good answer, you know what? They come a dime a dozen, go find the right one. Okay, the next question says, if you pass, will they still be valid? Everything in your estate plan is valid except the powers of attorney, remember, when a death occurs. All right, Miss Diane, or Miss Evans, if a spouse has dementia and cannot pay bills, what should you set to take care of the spouse if the other spouse should pass first and there are no children? Great question. Okay, so one, you need to have powers of attorney, right? And then you want to have succession. Specifically, and this is me just in Indiana, we can put what's called a delegation language in there so that when I draft a power of attorney for myself, I can allow my agents, I'll have succession, and then if my successors say they don't want to do it or they're unavailable, they can delegate. They're still on the hook, but they can delegate roles to other people to assist them. So you can have delegation language in there. But the important thing is to get your powers of attorney in place so that you have someone to manage those. As far as the no children piece, that's where the legacy piece comes into play, right? Or maybe you consider a trust-based plan. So a lot of times when we're single and we don't have those built-in protectors, for the future, then we might consider trust-based planning because trusts are contracts. Trusts are under fiduciary standard, which is the highest standard under the law. So if you give money to the wrong person, misuse the money, you get really tough penalties with trust-based planning. So a lot of times when you're in that position, a trust-based plan may be the vehicle that gives you the security, especially if you don't know if the spouse should become disabled, in the future too. The next question from Miss Camilla, she says, what are the drawbacks to starting late? Dying. I think, right? I guess that's it, right? That's the drawback. As long as you live to see another day, and let's get it done. I'm not being facetious, but it was good, and I'm a funny person. So this is me in my office and outside my office. So if you don't like it, you definitely don't want to come to this practice because I'm not changing. Okay, as my parents. Okay, but essentially, we have a really good time in my practice. That's why I have so many clients. But then it says. There are a lot of, do you suggest to begin the journey of growing knowledge in this? Where do I suggest? Books, articles, yeah, you can read them. There's just always something missing out, right? So when you read articles, sometimes they're very short on the extra content, right? They give you, they know your attention span is very short. In the National Network, actually, Rick Randall actually wrote a book. Rick, shout me out, on estate planning. And it's a book that basically talks about the concepts, especially of a living trust and what it can do for you in family dynamics. He's going to beat me up because I don't know the name of it. we'll get it to you. Search Rick Randall. The book should, he's Rick, I think it's Richard L. Randall. So Richard L. Randall, Indianapolis, Indiana. He wrote a book. I don't remember what it's called. He recently wrote it, so it's good. It's up to date. He speaks in plain English. So, what's my cut? No, just kidding. Just kidding. Okay. Okay. Charity asks, hey, Charity. What is the best, I do know her, what is the best way to save for college fund if you want to send your child out of state? So the best way to save, I mean, it's multiple vehicles, right? So some people do 529 plans, but 529 plans, you can give $5,000, you get $1,000 credit. If you don't need that credit, then that might not be a good vehicle. If the 529 that you're investing in has very static assets or static products within it, maybe you could capitalize on investing in other assets that are outside of a 529. So I'm going to leave that to the financial advisors. They're going to very much appreciate me tossing that up. But essentially, you just want to start now and just start saving. Whole life policies are a great way to invest for college funding because with a whole life policy, you can borrow against the cash value. So hence, if you start at age 0, right, and by the time 18 years has developed, you know, your child is 18, 19, something going to college, we have some monies that we can borrow against, right? So that's a good, and the policies or the interest rates within the policies are pretty reasonable. And then if you don't pay it back, then they'll just decrease it from the death benefit. So I just had to just pat myself on the back, y'all. I'm spitting this out. But essentially, I'm a very good learner. But essentially, a whole life policy is a good vehicle too to use because it does do two things. You're getting the life insurance aspect and you can do the investment aspect. So life insurance agents are going to love me for this. Again, I'm at 3750 North Meridian, Indianapolis, Indiana. I'm just kidding. Sandra Harris, she says there are abundant websites for organizing and develop your own personal living will documents. I think you mean last will. What are the pros and cons? My granny said it best, you pay for what you get. So, yeah. That's a very loaded question. So, it depends on how well versed you are in what the documents can and cannot do. And so then you can get the document. If it's tailored to your state, there are some products that are tailored to state specifics. There are some that just throw every requirement. Like I've gone on some of them and they don't know that Indiana doesn't require a notary. So guess what they do? They create a will that has witnesses and notary. So you do it all. I mean, you don't lose, but just get an attorney. A good one. That's all I got. I really do. I'm sorry. I wish I could tell you that, there are some things you can do yourself, right? But this ain't one of them. It just isn't. And you just got to chalk it up. It's an expense. We walk around with designer purses. We go to the mall. We go on trips. I see y'all in Tulum. I see you, Get the plan with me. No, just kidding. Just kidding. Okay. Let's see. Again, this is no shade. I'm just being silly. Okay. It's a very fair question, but the public needs to know, and I think you know that. This is Miss Shelton asks, I believe I am set in regards to life insurance. It's just everything else I really don't have. Okay. Okay. You don't have any other investments? Okay. That's okay. Because you can start today. Right. So the funny thing about money is the way it compounds. You can't do it in your head, right? That's why they have all these high-tech illustrations with different financial practices, because the minute you start, the compound is crazy. Like, I remember when I first started my first job when I was working for Rick, because he was the CEO of the National Network, and I was working for him, and he offered a matching program. I'm like, I don't have any money. I'm just going to give my little pennies so I can get my little 3% match. Man, I looked up and I had $20,000. I said, when did this happen? Because you set it and forget it. And you put it in the right products. My advisor was able to look and see what I was invested in. And every now and then he made me switch investments with it that were available to that product. But the compound, it blows your mind. Just start, and then don't worry about it. Let your advisor, if you're concerned about the type of investments, then you kind of check in and like I said, don't set it in. When I mean set it and forget it, I mean don't touch it. Not necessarily don't look at it. I'm not going to be that imprudent, but yeah, so just start. Don't beat yourself up about it. Like, the goal, and this is all I always tell my clients, Your children and your beneficiaries, they've already received their inheritances, folks. What comes later is a check. Okay, so spend your money. You worked hard for it. There, got an amen in here. It's yours. Stop waiting. The minute you retire, use it, right? So, because people always put off, I'm going to do it then. Nobody told you get to get there, right? And I've had a client specifically, and she was pissed because her husband, he wanted to wait to use it. Nobody told him he got to wait, and he didn't. He didn't get to wait. There was a death. So they didn't get to travel. They had all this money. Guess what she's doing now? Using it. Okay, so use your money. You saved it. Again, work with your CPAs and your financial advisor. We have longevity in our money. I'm not telling you to go frivolously save it, but yes, leave stuff to your children. You want to set your children up for future generations, but you have to enjoy your money. So, so that's that piece. Other than that, do you guys have any questions? Like Pastor Hudson, you want me to take any in the room? Does anybody got any questions in the room? Go ahead. Okay. Right. That's for them, but yeah. Okay, so the question is about Medicaid, which I knew was going to come up. Medicaid is a beast in and of itself, but essentially there are two phases when you think about Medicaid, or two phases for yourself. There's while you're alive and there's at your death. Okay, when you do living trust planning, remember I said when a death occurs, it becomes irrevocable. If you leave assets in trust for your beneficiaries, then those assets can potentially be Medicaid protected for your beneficiaries, okay, as opposed to just giving it to them outright. But while you're alive, what can you do, right? So Medicaid, he did go over some of the rules. Okay, so Medicaid is a two-part test. It's an income test and it's an asset test. Really, they want to be the payer of last resort. They don't want to pay. They want you to use all your money, then they'll pay. So they set this test. You can have only income. Every state is different. So I'm going to just say, I'll use Indiana numbers just to be, and I'm going to round up and round down. So do not put a pin in this. But essentially, say $2,000 a month you can have in income in Indiana. It's considered income for the first 30 days. The first day of the following month, it becomes what's called an asset or a resource under the law. But an asset, it's easy to comprehend. You cannot have any assets when you're trying to apply for Medicaid. So if your income exceeds that limit, by the first day of the next month, they'll kick you off and say you need to figure out how to pay yourself until you get back underneath, okay? Now, that's income. Income, if your income is over, so say you're not spending as much because you don't have any needs, so it keeps piling up and it keeps piling up and you can't spend it all down. Indiana allows you to set up what's called a Miller's Trust, which is a trust that is attached to your bank account and you can sweep the excess into it. Now, the catch with the Miller's Trust is any monies in the Miller's Trust must be used for health care. Only health care expenses, so it's very limited in its use. And the second catch is, at a death, the primary beneficiary of that Miller's Trust is the state of Indiana. So they get to get repaid back first for any monies they've outlaid on your behalf. The contingent would be your family, but guess what? There ain't be no contingent money, right? I mean, we got clients right now that have got $12,000 a month stay at a nursing home, or it's astronomical. There's never going to be any left over. It's a trick. Okay, so that's the income. Part two is the resources, the assets. You can have no assets, essentially. There's what's called a community spouse. Oh, and it just hit me. Why did I just draw a blank? The community spouse is the person that lives in and the institutional spouse. There we go. The community spouse is the person that lives in the community. The institutional spouse is the one that's either going to live in the home, because we can do Indiana. There's two types of Medicaid. There's traditional Medicaid and Medicaid waiver. Medicaid waiver allows you to live in the home because they do encourage people to age in place, okay? So you can have an institutional spouse in the home if you're doing Medicaid waiver because you want to stay at home. But essentially, what happens is there are much, much more strategies to save the money when you're married. When you're single, the strategies are much more limited. But they don't want to say, let's take a single person because it's easier. They can't have any assets. So what people say is, let me give away some of my money. And Medicaid, like you said, sir, looks back 5 years to see, did you give away monies you could have otherwise used to pay your own way? Giving away money is called a transfer, and it's considered improper if it falls within the 5 years, okay? And so what happens is a transfer is defined as if I give money to children or any individual. Now, they do give you a little what's called de minimis, so they'll let you give a small amount to children. We know we got to help our children, so they'll say, oh, you can give $1,200 per child. Everything above that is an improper transfer. Some people say, I'm going to set up a trust, an irrevocable trust, okay? That's still a transfer because you took money and put it in a trust. And when you say and I'm trying to be clear and I don't want to confuse people, but when people say I'm going to put it in an irrevocable trust, it's not a trust that you created. Someone else created the irrevocable trust. So and doing a trust is a strategy to get qualified for Medicaid, because there are millionaires on Medicaid. Don't get it twisted. You do not have to spend down all your money to get on Medicaid. I have clients that are on Medicaid and they have money. They're leaving money to their children. What happens is, one of the strategies is we intentionally give money to the children, but we leave money back to pay our way through the penalty. So if you give away money during the 5-year period, let's say you gave away $70,000. Medicaid says we're going to take the average cost of a nursing home stay in your state. Say, I'm rounding up. In Indiana, say it's $7,000. So 70 divided by 7 is 10. So Medicaid will say for 10 months, you have to pay your own way. The first day of the 11th month will pick up because you gave away 10 months of the nursing home payments, right? So that improper transfer disqualifies you. And Medicaid says, well, you can cure it by either getting the money back or the family can pony up the money and pay the way through the penalty. That's your options. So one of the strategies when we're talking about irrevocable trust is us attorneys will intentionally give away money, but keep enough money back to pay our way through the penalty. So we may, for instance, we're doing this with several clients right now. We gave money, say she's my child. I give you my $70,000. Knowing I just created a 10-month penalty. But I don't want you to just put my money in your bank account. What if you're married and you get a divorce, you get sick, you have a lawsuit? I don't want my money tied up on that. And Medicaid knows this. So what we typically will have you do, that I just gave child one my money, set up an irrevocable trust. I'm the beneficiary during life. At death, it goes to my children. You can be the trustee because you're my trusted person, right? You're my power of attorney. But that 10-month, the monies that we set aside to pay our way for the penalty, it cannot sit in my bank account because I'm ineligible, right? So what we do is we take, because you have to otherwise be ineligible, right? The penalty doesn't start until you're eligible. So you can't have it sitting in your bank account until the 10 months runs out, else you were always ineligible through that entire 10-month period. So we have to get those payments, and what we typically will do is buy a Medicaid compliant annuity. So it's a Medicaid has approved the laws of, the federal government has approved certain annuities that provide payments, equal payments to an individual or usually to the institution is who we're paying it to. So this Medicaid compliant annuity will hold the money to pay whatever the nursing home fee is. And it'll pay it directly to the nursing home. So the minute the money runs out of that Medicaid annuity is the minute that the government will pick up payment. So that's a strategy. And when people talk about, I'm going to set up an irrevocable trust, there's a lot more to it. That's why I tell people, you only got half the information. Because there were a whole bunch of steps till you got to that annuity, right? We had to give the money, create the penalty, buy an annuity. And the annuity is about it can be somewhere between $1,500 to $1,600. There's companies that sell them all the time. I know it's a loaded question, but that is a full and complete answer. But the other thing, too, is with Medicaid, there are also exempt things. So you can, like in Indiana, we can prepay for the funeral for some of our children. We can prepay for our own funeral if we're going on Medicaid. We can prepay for the funeral of our children. We can, you're allowed to have one home. So that's where married people, the home is exempt. If you're single and a child has lived in the home for at least 2 years prior to your application, we can exempt the home for a single person. If a child has special needs and lives in the house, we can exempt the house for the special needs child. We can then use some of the money to improve the house because it is exempt. So if we're still over our assets, we can take some of that money and put it in the house if it's exempt, so that we can get the money off the books when we're trying to apply for Medicaid. So I will leave it there, but I'll just tell you that don't wait till you run out of money. But the biggest thing is you're going to have to pay some money to save some money. So stop being cheap. And the funny thing is people being cheap with other people's money. You don't be cheap with your parents' money. We trying to get you the money. Like, if they want you to get the money, we want you to get the money, but you got to pay. Because as you can tell, there are a lot of strategies and intricate things that go into qualifying yourself for Medicaid, but it can be done. And we can save, with married people, we can save a significant portion of the assets. With single people, 60 to 70% we can keep. But and the attorney's fees are a part of the spend down. So that's the little bright side. So you maybe spend a little money, but we factored in, we help you. Hopefully in more ways than one. But that's all my questions. Great question, loaded question. Hopefully, that helps people get a little idea of Medicaid. If you guys have any other questions, there's my, social media. You can follow me on all handles. So Norton Estate Planning is my law firm. I actually own the building. If you're from Indiana, that has Planned Parenthood on 37th and Meridian up here off of 38th and Meridian. So that's our building. You can find me there. You can go on my website, estate-planners.org. I don't do Twitter, but it's on there. And I'm on Instagram on 2 different accounts. I'm on my law firm account, Norton Estate Planners, and I'm on the Legacy Strategist. So tomorrow we'll be going live at 5 p.m. to answer questions if you were online and you didn't have an opportunity to ask me some questions. 5 o'clock tomorrow on the Legacy Strategist on Instagram. You can find me, and I'm happy to answer any questions. But again, just go to the website, search my name. You should find me on all forms of social media. I'm on Facebook, all that, LinkedIn, yada, yada, yada. But thank you guys for having me come. I appreciate it. Thank you, Pastor Hudson. Fun as always.